In negligence law, there is no duty of care to protect a person from risks that they voluntarily choose to take. In Latin, voluntary non fit injuria, or a volunteer cannot be harmed. This is especially important in adventure sports, which inevitably come with some risks attached. In this case, the sport was water skiing. The parties were part of a group of 5 experienced skiers who took turns driving the boat and turns executing complex and dangerous manoeuvres. On the day in question, Roots, the plaintiff, was one of 3 skiers attached to the boat performing a crossover trick where they swung back and forth, going over and under one another's tow ropes. The usual practice was for the boat driver, obviously, to steer clear of obstructions, or for the driver or an observer to signal to the skiers if there was an obstacle ahead. This time there was no observer, the driver failed to indicate, and Roots found himself at the extreme end of his swing, very close to an anchored boat, which he could not avoid. He crashed and was badly injured. The question for the court was whether the boat driver, Shelton, should be liable, or whether the voluntary non fit injuria principle should be applied. Justice Taylor set out the question this way. There were certain risks inherent in the sport in which the participants, including the appellant, were engaged. They were obvious risks about which the participants could not complain, and that it was for the jury to say whether Roots's injuries had resulted from his exposure to such a risk, or whether they had resulted from his exposure to some other and additional risk. Justice Owen then said, to say that the appellant voluntarily assumed the risk of colliding with an obstruction in the water is one thing. To say that the appellant voluntarily undertook the risk that the respondent would carelessly fail to warn him of the presence of such an obstruction, or would fail to exercise due care in steering the boat of which he had control, is a very different proposition. So the mere fact that the activity was dangerous did not mean there could be no liability at all. Rather, there was no liability for the inherent risks, but the participants still had a duty of care to protect one another from other avoidable risks. Roots was entitled to compensation.